right, it's great. Good afternoon, everyone. So far, we've made it without tripping, so it's a success so far. It's nice to be here. My name is Ashley Savinov, and I'm joined here by my friend Linda. Linda and I first presented together actually when the OHS regulations first came into force, so just prior to 2020. So the gang's back together again, and hopefully we have some good nuggets of information to share with you. Certainly, we do have a lot of information to cover, but if you have any questions, I think you can make your way sort of to the microphones or someone will find you so we can hear you. So here's the overview for our session today. We're going to set this up by going through the legislative framework regarding workplace harassment investigations in our jurisdiction. We're then going to talk about investigating workplace harassment generally. We'll take you through what the guiding principles of any proper investigation are, talk about how someone would make a workplace harassment complaint or not, and as an employer, how you become aware of workplace harassment and then what you need to do. We'll discuss briefly the investigation process, and then Linda is going to round it out with the role of occupational health and safety officers in harassment investigations. So you're likely all aware by now that our OHS regulations were amended effective January 1, 2020. And those amendments required all employers in our jurisdictions to have workplace harassment policies. Harassment prevention plans is the term used by Occupational Health and Safety. The amendments to the OHS regulations also address, in addition to harassment and harassment investigations, it also addresses workplace violence. And a lot of the times I get asked the question, well, why are we now dealing with workplace harassment in occupational health and safety? Isn't this just, isn't this a nice to have policy for larger organizations? And of course, we now have a recognition by the legislatures and by society that harassment and violence is certainly a hazard in the workplace. It has the potential to be catastrophic impacts in your workplace. And as employers, you have a legal obligation to ensure a healthy and safe workplace for your workers. And that includes a workplace that's free from workplace harassment. So our regulations also tell us how an employer is required to address workplace harassment. And this is all outlined, by the way, it's the plan, the details of the plan is outlined at section 24.1. So as employers, and if you're an employer or as you're a worker, regardless, this is sort of the section that applies, and it tells you what an employer is required to do to address harassment. So employers are required to develop, implement, maintain a written harassment prevention plan. So in your workplace, you may call it a respectful workplace policy. I tend to call them that when I draft them, but the regs use harassment prevention plan. Linda and I just discussed that in terms of the proper name for the policy. And this is to be done in consultation with your OHS committee. You're also required to participate in, so as an employer, participate in and provide training to your workers on the policy and also on harassment prevention generally. So it's not enough to provide workers with the policy, say, have a read through, sign the acknowledgement on the end and turn it in. That would not meet the requirement in terms of having conducted training on your policy or harassment prevention generally. And our focus here today, of course, is on investigations, and our regulations set out that you are required as an employer to investigate complaints of workplace harassment. You'll see in the regulations as well, there's very precise statements that need to be contained in the policy, certain language that needs to be used, certain procedures, and we're going to focus on the investigation sort of aspects of the regulations. All right. So what is workplace harassment? It's defined in the regulations. I'll go through it just briefly here, and a lot of large words, but I'll try to break it down. It's inappropriate, vexatious conduct or comment by a person to a worker that the person knew or ought to have known would cause the worker to be humiliated, offended, or intimidated. So vexatious, I'm sure, maybe you use this word a lot in regular language. I don't. Vexatious just means annoying or irksome, irritating, okay? That's what that means. So it's inappropriate, sort of irksome conduct by a person to a worker that the person knew. So they actually had knowledge. This could be someone saying, I don't like it when you say this to me, or this is embarrassing, this is intimidating, this is humiliating. So then you would know, or ought to have known means even if you're not told that the conduct is inappropriate or humiliating, that a reasonable person taken into consideration all the circumstances would know that this would cause a worker to be humiliated, right? Offended or intimidated. So that's the definition that we're dealing with in terms of our policies. The regulations also set out what is not workplace harassment, and that would be any reasonable action taken by an employer or a supervisor relating to the management or direction of the workplace. So if you're doing discipline or performance management, anything like that, as long as it's done respectfully, that would not amount to workplace harassment, okay? So if you got a complaint and said, well, my supervisor told me I had to stay an hour late, I want to make a complaint of workplace harassment. So right off the bat, you're going to go to your policy and likely the definitions will be set out and you'd say, well, even if all of that were true, that would never meet the definition of workplace harassment. And in fact, our regulations expressly excludes it. So that's not workplace harassment. I don't need to investigate it, okay? This definition, though, is broad enough to include human rights related and non-human rights related harassment. And what I mean by that is that in addition to harassment on a prohibited ground in the human rights legislation, so that would be things like sex, race, color, gender expression, gender identity, and all of the list of prohibited grounds, it also includes things, harassment just for any reason whatsoever. So when you think of like personal harassment or bullying. So really what we see in the regulations is an attempt to legislate and regulate civility and respect. So prior to the regulations, the only real kind of complaint process that you had, in the statute was human rights related. So if your complaint was just in relation to bullying or harassment, but it wasn't because of a prohibited ground, then really you didn't have any sort of recourse under the legislation. Now this is being dealt with under occupational health and safety. Okay, you with me so far? It's really hard to see, so. Okay, so the regulations set out as well kind of the policy must-haves. And in terms of reporting and investigating workplace harassment, it doesn't outline the details of the process or procedure that you must follow, but it does say that you must set out the procedures to be followed. So you need to set out, how is someone going to report an instance of harassment in the workplace, okay? How do you make a complaint? So that should be very clear to anyone in this room, in any workplace. If you observe or you experience workplace harassment, you should be able to turn to your policy and see, okay, well, how do I make this complaint? Your policy also has to include procedures to report harassment to an external third party. And what this is intended to address is a situation where you wouldn't have to report the harassment to the alleged harasser or someone who reports to the alleged harasser. And we're going to talk about sort of the guiding principles of a proper investigation, but certainly I don't know how comfortable you'd be to say, it's myself and my CEO at my workplace. I have a complaint of harassment against my CEO. I'm going to report it to my CEO. So how do we think that's really going to go? So in those circumstances, you would have to identify in your policy someone completely external to your workplace. Could be an HR consultant, any sort of external source that would deal then with the complaint. Or if you're a larger organization, it could be someone completely sort of outside the department, right? So maybe the HR department, someone within that is completely separate. The whole point is that you don't want the person investigating the complaint or receiving the complaint to influence the process, because it's very important for everybody involved that the process is fair. You have to outline the procedures to be followed after a complaint is received and the manner that it's going to be investigated. So that may look differently depending on your workplace, but you have to set out the procedures so that the expectations are clear as to what's going to happen once a complaint is made. You also have to outline procedures regarding the notification of the results of an investigation, as well as any action to be taken as a result of the investigation. So a complainant and a respondent would get the findings of fact, and that just means whether or not an allegation was substantiated or not. They generally would get, unless your policy says otherwise, and unless you're subject to ATIP and there's a request, and I'm not going to go into that for the purposes of our presentation today, but typically they would just get, the findings of fact. Witnesses would not get the report or the findings of fact. They would generally just be entitled to a copy of their statement, okay? In terms of actions to be taken, that just means generic corrective action. So if a complaint is founded, you would not indicate to the complainant that, oh, and we suspended the respondent for 3 days. You would simply say corrective action has been taken, because again, you're looking at protecting privacy of the respondent as well. So let's dive into investigations generally. How are we doing back there, Linda? Good. Okay. So when, just as a heads up, when at my firm, we often do harassment investigations training, and the training course is 5 weeks at an hour and a half each week. So this is very much an abridged version of kind of an intro to workplace harassment investigations. I wouldn't do that to you, make you sit here for a day and a half. So the guiding principles that basically follow any proper investigation. The first two are thoroughness, timeliness, and then we have confidentiality and fairness. And I'll take you through just generally what those mean. So once an investigation is commenced, you need to ensure, any investigator going in is going to ensure that it's thorough enough to address all of the allegations in the complaint. Okay, so firstly, when an investigator is assigned to conduct the investigation, they're going to make sure they have a thorough understanding of the allegations, and then they're going to conduct their investigation in relation to those allegations, all right? So it's not a fishing expedition, it's not some sort of witch hunt. The investigator is a neutral party who's trying to get kind of to the facts to determine if the allegations are substantiated or not. And just for your information, substantiating doesn't mean, the criminal standard of beyond a reasonable doubt. We're talking about a balance of probabilities. So 50% plus 1, that's substantiating your complaint. If it's 50-50, if you can't make the decision based on the information you have and you've exhausted your investigation, the complaint is not substantiated. Okay, so balance of probabilities is 50% plus 1, and that's the civil standard at law. So that's what an investigator is looking at when they're making their determinations of fact. In terms of timeliness, there should be a sense of urgency in completing the investigation, and you want to make sure that you address any allegations of workplace harassment as soon as you can. You want to make sure that your workplace is a healthy and safe place to be, and that any sort of hazards are removed from the workplace. However, certainly you're likely going to come across circumstances where you may be kind of slowed down or the investigation may not be able to proceed. So for example, oftentimes if someone makes a complaint of workplace harassment, there may be a worker who goes off on sick leave and they may or may not be available. So that will be something that would impact the timeliness of being able to complete the investigation. And of course, you kind of have the competing factors of thoroughness with the timeliness. So you're sort of trying to strike a balance, and any investigator is going to try to strike that balance when they're conducting their investigation. Confidentiality is crucial to any investigation. It is set out in the regulations in terms of that information gathered in the course of an investigation should not be disclosed except to conduct the investigation or to disclose as required by law. Okay, so It's important that anyone involved in an investigation is aware of the confidentiality requirements. This would be expressly addressed in your policy. Typically, the parties would also be reminded during the process by the investigator. They would also often be asked to sign a confidentiality agreement before participating in the investigation, okay? And again, you're trying to ensure the minimal disruption to your workplace when this investigation is ongoing. You don't want to any of the witnesses or the complainant or respondents to be influencing one another or changing people's memories or their account of what they actually witnessed. And you also don't want sort of the gossip mill. And it's difficult. Look, it's you know, especially a small workplace. We live in a small city. You want to try to keep that confidential as much as possible. Certainly most of the policies, if not all of the policies I've seen, indicate that if you breach confidentiality, you're breaching the policy, and that could result in termination of employment or other forms of discipline. And think about kind of the people engaged in this particular investigation, right? Their level of comfort with telling the investigator kind of their side of the story, what happened, is absolutely going to be more, I guess, close to the truth if they're assured of the confidentiality of the process. And finally, fairness. And it's typically, you know, as a lawyer, if I'm going to look at an investigation and it forms part of, say, a wrongful dismissal complaint, that's where I'm going to look to challenge the investigation is, well, what was the process that was taken? You know, did the respondent in particular, because that's often where you have the challenge if, say, for example, the complaint was substantiated and then as a result, the respondent is then, say, terminated from employment for breaching the policy. Well, the first place I'm going to look is the process that was followed as part of the investigation. And I'm always surprised by how many people struggle with this element, but an alleged harasser or the respondent has a right to know the case against them and an opportunity to be heard and to respond to the complaint against them. So you can't properly respond to an allegation if you don't know what you're responding to. So I've seen, you know, some very interesting case law out there when the investigation process to the respondent, and this wasn't an allegation of sexual harassment. It's a case from over a decade ago in Alberta, and it was, you know, serious allegations against him, sexual harassment, which turned out to be malicious and false, which came out after the fact. But when he asked for the allegations against him, the investigator said, "You know what you did." So that's not a proper investigation. So you need to be sure that the alleged harasser has the opportunity to respond to all the allegations against them. Complaints. So typically in your policies, your harassment prevention plan, you'll likely see set out again how a complainant would make a complaint. And oftentimes you may see a template, say, at the back of your policy or list of things, what you're requiring in terms of a complainant statement. And that could be, you know, in writing or, you know, outline, okay, where did this happen, the who, what, when, where, why, identify any sort of witnesses and submit it. So in those circumstances, it's sort of, you know, the easier situations to deal with. You get your complaint, then you look at terms of, okay, well, are we going to do this investigation internally or externally? And I'll get to that in a moment. And then you're following your policy. The trickier situations are when you have an anonymous complaint or rumor in the workplace. And in those cases, it may just be general issues of workplace harassment or bullying, and there's no parties named. It's just sort of out there that someone is reporting that, you know, you have an issue in your workplace. And so, you know, what do you do in those circumstances? Typically, and my advice is always to address those circumstances in your policy, indicate that as an employer, you have an obligation to investigate complaints of harassment, and you'll do that to the greatest extent that you can in accordance with your policy. But there may be circumstances where you don't have enough information to go further, and you may then look at doing, say, a workplace survey or some sort of assessment anonymous to your workforce to see kind of do like a pulse check to see, what is going on here. Are people raising concerns? What do I need to be looking at? And usually that's when sort of these things start to come to light. Linda, what about anonymous complaints? And you've probably, come across this. Do we still have to investigate?
Is this working? No.
You come on over.
Thanks. We do get complaints actually in our office from people who want us to have a look at the allegations. And one of the things that we don't do is actually investigate the allegations themselves. But what we recommend to employers is that when they, like Ashley said, when there's a complaint or a lack of a complaint, maybe a rumor or gossip or something along those lines saying that there is harassment and bullying, it is required that people look into it and that employers have a look. One of the things that we also like to say is if you're having trouble figuring out where to look, there are a number of things you can do that Ashley already mentioned, like the workplace assessment or a survey. And there's also a lot of information out there, psychological, occupational health and safety. And things like Guarding Minds, which is on the web, you can find a lot of information there to help you try to seek out how people are doing in the workplace. And you'll often find some responses regarding harassment that's going on that you didn't hear about otherwise. And the other thing I was thinking about too was that in actual fact, when you're doing your safety inspections, you really need to be doing that with the inclusion of workers anyhow. You need to be speaking to workers when you do your workplace safety inspections. And that's another opportunity to talk to people and ask them how things are going. It's not likely someone's going to say, well, actually, and give you all the details right then and there when you're doing an inspection, but it's an opportunity to get a feeling of things. So unfortunately, it's not an option to sort of say, well, it was anonymous, so we're just not going to follow up. And that's what we usually tell people if they call us and look for advice on that.
Thanks, Linda. So I guess the point being, the regulations do say you shall investigate complaints of workplace harassment. So you can't push it back and say, well, it wasn't in writing, or, well, sort of anonymous. Or you'll get a situation where a complainant tells you the information and it's very difficult for them to maybe come to that point. And then they say, but I don't want you to do anything about it. I don't want you to act on it. And as an employer, certainly you have a legal obligation to address it, to kind of deal with the hazard in your workplace, and certainly ignoring it is at your peril. We're going to take you through now a discussion of kind of the investigation process. So what to expect once an investigation starts. So you can approach this from the point of view of an employer or as a worker, and just to kind of have a general understanding of a workplace harassment investigation. All right. So I guess first, it's not on this particular slide, but the first decision that the workplace or the employer is going to make is, do I do this internally? Do I have someone internal carry out this particular investigation? Or do I go external? Do I get an external investigator to come in? And, that would depend on a number of factors. Firstly, you'd look at, okay, well, do I have the internal resources to do this? Do I have someone, and often it would fall to human resources. You would look at, well, do I have, a trained and experienced investigator who can properly do this investigation? Or even if they are trained and experienced, can you allow them sort of the time to conduct the investigation? And depending on your workplace, can they truly be neutral? Could this be a situation as an investigator where they may get into it and say, well, I know Joan, I can't see her doing this. So if as an investigator, or you feel like you can't do this fairly and neutral, then in that circumstance, that's not the right investigator for your organization. Other factors to consider would be, who are the parties? So are we dealing with two, say, bargaining unit employees, or are we dealing with management and a bargaining unit employee? So oftentimes, if someone's at the same level within the organization, then you may want to keep that internally. But if you have kind of that power imbalance from the start, you may want to get someone external to conduct that investigation. And for the actual kind of neutrality, and also because they don't bring with them the history of the workplace. They're completely new to the organization, which, pros and cons. Sometimes having that insight of just how the workplace works is helpful, but they don't come with any sort of outside biases or understanding of the personalities that they're dealing with. They're purely dealing with the allegations. Also, in terms of the complexity, like how many allegations are in the complaint. So that would also kind of dictate whether or not you're going to get someone external to come in to the workplace and carry out the investigation, or if you think it can be handled internally. And also, kind of in my world, what's the probability of litigation? Do you think this, no matter what the outcome, obviously someone's probably not going to be happy, either the complainant or the respondent. So if you think there's a likelihood of litigation, you may want to get someone external to come in and who's trained and experienced in the area to conduct the investigation. So in terms of the scope, what I mean by that is, as an investigator, they're there to investigate the allegations. And in most cases, they're there to make findings of fact. So was allegation 1 substantiated? All right, what did they find? They may also be asked to determine, okay, if I find this, is this a breach of the policy? Did this amount to workplace harassment? All right, so they're going to be looking at your policy to determine if there's a breach. In some circumstances, and this is typically not my recommendation, but investigators are asked to provide recommendations. So after the investigation, what they recommend should take place as sort of a next step. Not typically my approach, because once you have that report, you may or may not agree with the investigator, and then you're sort of faced with these recommendations that you may or may not choose to implement, and then you would have to explain why you chose not to make those recommendations. Typically my approach is, your workplace best. Once you get the results, you can then determine what the best course of action is based on the findings that the investigator makes. In terms of the interview, so once there's investigation started and the complaint is in, and the investigator is going to assess the complaint, they're going to make sure that they fully understand the allegations. So typically they're going to take the complaint and they're going to summarize that in a few maybe bullet points or a narrative to outline, okay, here's what I'm investigating. They'll then go back to the complainant and say, here's my understanding of the allegations. Is this your understanding? Are we all on the same page? And then once you're on the same page, you do your interview with the complainant, and you get a better understanding of kind of the who, what, when, where, why, right? Understand all the details. They'll typically, so at that point, you'll know the identity of the respondent. And the complainant's likely going to tell you different witnesses who may be able to provide information through the course of your investigation. You may have these interviews at an off-site location. And again, this would depend on your workplace. And, I always kind of tell the investigators who we're doing training with, always go back to kind of your guiding principles, right? Go back to those sort of principles of, confidentiality. So can an investigator come into your workplace, conduct an interview, or carry out their investigation, in the workplace during working hours without people kind of wondering what's going on, right? So that would depend on your setup, but likely not. Oftentimes we're seeing more and more that these interviews are going to take place via, virtual or on like Teams meeting or Zoom. So that's also happening, right? Typically the investigators either going to take notes and kind of craft a statement of the parties and get them to sign off at the end, or they may record with a recording device so that they have an accurate record as to the evidence and what was said. So those are certain things that you may see in the process. So again, the parties, and by parties, I mean the complainant and the respondent. In terms of, I think I've kind of talked in detail about the complainant, but for the respondent, in most cases, and this would likely be in your policy, you would provide them with a copy of the allegations before the interview. So as an investigator, you're not kind of going for the, I gotcha, you can't respond to this, or the aha moment. You're an investigator. You're a neutral investigator. You're there to determine the facts of what happened, right? So you're not looking for that sort of smoking gun. You're looking for the truth and the information as to the allegation, okay? So it shouldn't be an adversarial process. It should be kind of getting to the truth of what actually happened. Witnesses would typically be, as I said, identified by the complainant or the respondent. And these individuals, it's sometimes challenging for them to be part of the process because they're usually brought in. Obviously, you would let them know, look, you're not the respondent here, but you may or may not kind of get into the details of the complaint, and their role may be very limited. So for example, there's an allegation that there was an incident of violence at a holiday party, and someone identifies Johnny as a witness. Well, Johnny was there, go talk to Johnny. And so as an investigator, you're not going to say, hey, Johnny, were you at that party and did you see so-and-so hit so-and-so, right? Because again, go back to the whole principles of confidentiality and keeping kind of only releasing what someone needs to know. So if you go to Johnny and say, Johnny, were you, I'm interviewing you as part of a workplace investigation. Can you tell me if you were at the holiday party? And if he says, no, I was out of town. You say, thank you very much, Johnny. And that's the end of your interview. So you don't need to go any further in terms of that particular interview. So sometimes it's challenging for witnesses because, as humans, we kind of have a desire to know and to get all the information we can. But if the witness cannot add any further information on the allegation or on the incident in question, then you're finished. Also, you may be in a situation where a respondent in particular, so the person who's the alleged harasser, to say, well, I'm not the type of person to do this. Ask all of my, 15 friends or ask my coworkers about the type of person I am. And again, you're going to go back to your guiding principles and, thoroughness. Okay, well, maybe I should talk to a few of these people, but there's likely kind of no need to go and talk to 30 character witnesses about the type of person that the respondent is if they can't add any details on the actual incident itself, right? So again, investigators are going to look at this and say, it's not what type of person, the respondent is, or they're not likely to do that, but did they on this occasion? Perhaps they acted completely out of character, right? So those are the sort of things you keep in mind when investigators are speaking to witnesses as sort of like a character witness. In terms of, I've noted here, support persons in legal and union representation. So typically if the respondent is being interviewed and they're bargaining unit employee, then typically union rep would be part of that meeting because it could be perceived or could result in discipline. You may also see situations where a support person is sought to be brought to an interview by a complainant or a respondent. So it could be a friend, a colleague, a family member. In those cases, typically, as an investigator, I wouldn't object to that. Again, your goal is to facilitate the information. And if the person is more comfortable with this person kind of sitting in the room, assuming they don't interfere and they're not there to make submissions on behalf of the person, they're not answering the question, then I typically don't have an issue with that. And sometimes the person just wants them to sit outside the door just to kind of have that comfort to know that they're there supporting them. And the same thing for legal counsel. Sometimes when you have legal counsel in the room, the person that you're interviewing has more comfort because they know someone's there who's sort of removed and has their best interests at heart. So when they can explain to the particular party that this is the process, this is what the investigator is going to do, and they're hearing this from legal counsel, they understand that, okay, well, I have legal counsel engaged. They're acting in my best interests. It's going to ensure the process and kind of gives them that added comfort. So unless someone's going to really disrupt the process, then typically, me personally, I don't really have an issue with support persons. And I would suggest that, there's certainly no issue with having them as part of the interview, as long as they're there just to be there, not to, intervene. And then finally, I made a note here about the investigation report. So I previously noted, so at the end of the investigation, once the investigator kind of wraps it all up, they've already interviewed the parties. They've kind of explored everything they can. They're going to write a report to the client. So if it's an external investigator, they're going to report it to the person who retained them. If it's internal, it may be reported to, say, management or CEO or someone. Again, the findings are what goes to the parties in this particular case, right? They wouldn't get the entirety of the report. And also the witnesses, the poor witnesses, they don't get anything. They may get a copy of their statement just that they signed off on as part of their interview, but they wouldn't actually get the report or the findings of the report. So that's sort of what I wanted to talk to you today about the investigation process. Now, Linda is going to tell you about sort of the role of OHS officers under the legislation when it comes to workplace harassment investigations. Linda?
Thanks, Ashley. So far, this is the easiest presentation I've ever done. So I'll just talk briefly, I promise, about what our role is as occupational health and safety officers. As I mentioned before, one of the main things to recognize is that we do have this in the regulations about having harassment prevention plan in place, but we're not, there's no requirement in the regulations or authority in the regulations for us to actually do a harassment investigation, which is what Ashley's been talking about this whole time. When people contact us and make an actual complaint, our authority allows us to say, okay, well, do you have a harassment prevention plan? Does your employer have one? And we can come in and perform an inspection. And sometimes it's a strictly harassment prevention related inspection because of the call we've got. And sometimes we come in and just do an inspection for harassment because that's just on our list of things to do that day. So it doesn't always mean we have a complaint or that you have experienced harassment in the workplace. So the only things that we look for, and they're important, is the harassment prevention plan needs to be written, it needs to be in place. People need to be aware of it. They have to have had the training on it and be aware of harassment prevention in general, but also about your own plan. And as Ashley mentioned also, it's not enough to say, yeah, they're trained. I put it on the coffee table in the staff room and everyone signed it. That's not training. So there needs to be a little bit more to it because people really have to understand this, and it's a very clear description in the regulations that that's required, training for this plan. The plan also has to have everything in it that is required by regulations. So if you go into our regulations, there are sections in there and it strictly says, here are all the statements you have to have. Here are all the procedures you need to have. My recommendation and the division's recommendation often is where it says, have this statement, then have that statement. Just take that statement and put it in your harassment prevention plan. If you start changing the terminology a little bit and sort of working around it and talking with a different language, it's probably fine, but you need to stay true to what the gist of that statement is. And sometimes that can lead to some problems if people do make a complaint and say that, like, I don't think our harassment prevention plan is meeting the regulation. So that's one thing to take into consideration. As I said, we don't investigate allegations. However, it is the employer's responsibility to do that. So if somebody comes to us with a complaint, we may go into the employer and say, have you investigated this complaint? And when they say, well, no, because actually it's with the police now, so we're not going to investigate, that doesn't take away the requirement from our regulations for an employer to do their own investigation. Same as if it's with human rights. So there is a requirement, and we'll ask that for when did you do the investigation? Did you do the investigation? And if, depending on the situation in the workplace itself, if it's a very small workplace, unfortunately, the smaller it is, the more likely it is that you're going to have an external investigator come in. And that's because of the same scenario that Ashley mentioned earlier. You need to have an impartial perspective when you're an investigator. And if your workplace, the smaller it gets, the less likely it is that there's going to be someone there that can have that totally impartial perspective. And sometimes they don't have the training, which is also difficult, makes it hard for that person to do it. So we may come in and say, it's good that you did the investigation, but we had a complaint about it, and it looks to us like you actually have to have an external person come in. And unless that's already underway, we would write an order that says this needs to take place. So you can see in the regulations that this is also not at the employer's cost. So because we write the order doesn't mean that we are going to do it or that we are going to pay for it. So it is difficult. That's a difficult section of the regulations for a lot of people to work with, and that's understood. However, it is because of the principles of the investigation. It comes from the thoroughness, timeliness, confidentiality, and fairness, mainly the fairness and confidentiality. If you can't achieve those things and the impartiality to do a good investigation into harassment, that's the biggest identifier for you. We need to get someone external, and it is for us too. So if we come in and realize that that's lacking, that's when we'll write that order. I don't think I really have a whole lot more to say. I guess I was going to ask with a show of hands who's had us in already on this, but it's a bad idea, so I'm not going to. But if anyone does see us coming and we're asking for your harassment prevention plan, it's just the same as any other inspection. Often we come in and say, can I see your respiratory protection program? Can I see, it depends on what we're there for and what sort of the division is trying to achieve recently, or it could be any number of things. So it's not always because of a complaint, but when it is a complaint and they say, please, could you go check this out? That's what we do, and we let you know. So, did you have anything to add to that? Like I said, easiest presentation I've ever done. Does anybody have questions?
Yeah. Okay, so if anyone has any questions?
There's in the back. Yeah. Yeah.
I just wanted to ask a question. I don't know if you guys can see me over here.
Hi, Jennifer.
Hello, Ashley. It's lovely to see you. I wanted to ask a question. I know that we spoke about complaints, I guess, within the workplace, employee versus employee, or maybe employer versus employee. But would there be anything different that you didn't speak about if you had a complaint that was an employee and a client?
That's a really good question. And no, so the policy should actually outline kind of what the workplace is, and it would be any sort of complaint of harassment that brings itself within the workplace. So it may be an employee making a complaint against a client, against a contractor. It could be kind of anything of that, because again, your obligation is to ensure health and safety at your workplace. So the workplace may be, if you're visiting someone's home, a client's home, right? As long as it's related to the workplace, it could be on social media, right? So if there's a complaint against a client, the same investigation sort of principles would apply. But obviously, as an employer, you don't have the control necessarily of the client. So they may refuse to participate. Say, I'm not participating in this, I'm not responding. You give them the opportunity to do so, and that would inform your report. So you would base it, kind of do it as much as you could with kind of the parties you have, but certainly any client, any external person would also fall within your policy. And typically we expressly outline that as well.
Thank you.
We have a question at the back. Sorry, my legs aren't as fast as they used to be.
Not yet.
Sorry for making you get your steps in. I just had a quick question. Thank you for the presentation. First off, that was great. Just to dial it back to the complaints again, in the situation where the complaint doesn't come through a formal process, it comes through, say, the report of an incident or of an injury report, which is somewhat of a different process or a different way in which it makes it to the employer. Would you still consider that at that time to be an investigatable incident?
So I think it would, obviously it would depend on the circumstances, but if you become aware as an employer that there may be that if what happened was true, would meet sort of that definition in the regulations, and I think you have the obligation to sort of drill down on that and to look into that. So, following up with the person who had some sort of injury, and ask them for more details. Again, they may not participate in the process. And again, that would inform your investigation report, but you need to, again, go through it as much as you can with the information that you have. I certainly wouldn't ignore it in that circumstance. Yep.
This might have been mentioned earlier as well already, but you need to think of it as a hazard in the workplace, which is why it's part of the occupational health and safety regulations and not outside of the regulations only. So it was introduced because it is a hazard in the workplace, and once an employer is aware of it, they need to address it, just like all the other hazards that are generally expected to be addressed.
Okay, I think that we're actually out of time for questions today. Thank you, Linda.
All right, thank you all very
Ashley.
much.
Thank you.